Good afternoon to everyone at today's public hearing of the Vetting Commission established under Law Number 65 of the year 2023 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I'm Scott Bales, the chair of the commission and panel B of the commission, and I declare this session open. The hearing is being conducted under Law Number 252 the year 2023 on the external evaluation of judges and prosecutors and amending some normative acts and under the Commission's rules of organization and functioning as part of the evaluation process. Subject of today's hearing is Ana Panov, a judge of the Central Court of Appeals, previously known as the Chisinau Court of Appeal until December 27th, 2024. Judge Panov, welcome.
Bună ziua. Good afternoon.
Judge, as noted from the hearing notice on June 20th, 2025, Superior Council of Magistracy, by decision number 328 of the year 26, rejected your evaluation report and ordered the Commission to resume its evaluation procedure. Thus, in accordance with Article 20 of Law Number 252, the Commission asks you to attend today's hearing. I'm joined by two other panel members. You will see in the room Commission member Willem Brouwer, and to your right, Commission member Iurie Gațcan. Panel is also by members of the Secretariat, and you may also see in the room members of the media public. You will notice a photographer is present. He will take pictures just at the beginning of the hearing. The hearing will be conducted with interpretation between Romanian and English. To allow for accurate interpretation, I ask everyone to speak clearly and slowly. Only one person should speak at a time. Furthermore, the proceedings are being recorded. Recordings of the public hearings of the Commission generally will be available online at the Commission's website, www.vettingmd, with www.vettingmd.eu within 3 days after the hearing. During the hearing, members of the Commission will ask you questions. We ask that you answer them truthfully and completely. Your explanations are important to the panel in verifying your financial and ethical integrity. At the end of the hearing, you'll be given an opportunity to make a brief statement. In posing questions, we will consider your privacy and, where required and possible, the privacy of your family members and close persons. We will omit unnecessary information relating to such things as ID numbers, bank account numbers, specific real estate addresses, and the like. For the protection of privacy, we ask that you do the same. I will start by briefly reviewing the evaluation procedure for Judge Panov. Commission initiated its evaluation on the 11th of April 2024, notifying the judge in email and asking her to complete and return an ethics questionnaire and the declarations required by Law Number 252. She did so in May of 2024. Between August 20th, 2024 and the 31st of December 2024, the Commission asked Judge Panov to provide additional information to clarify certain matters during 4 rounds of questions. In each of the rounds of questions, the subject requested extensions. The Commission accepted her extension requests. On the 30th of January of 2024, we notified Judge Panov that the panel had identified some areas of doubt about compliance with the ethical and financial criteria, and we invited her to attend the hearing. On the 22nd of April 2025, the Commission adopted its evaluation report, recommending that Judge Panov promote the external evaluation under Law 2. On the 20th of June 2025, as I noted earlier, the Superior Council of Magistracy, by decision number 328/26, rejected the evaluation report and ordered the Commission to resume its evaluation. During July and August of this year, Judge Panov was asked 2 rounds of additional questions. She provided answers. On October 3rd, we notified Judge Panov of the Commission's remaining doubts and asked that she attend a second hearing this afternoon. Judge Panov, let me ask initially, do you wish to make any corrections or additions to the answers you've provided to the Commission's request for information?
There is nothing for me to add. I would just like to stick to what I have already stated and what I have already made available in the previous rounds. For the first and the second, the resumed evaluation for now as well, I provided for this hearing, for this part, I've provided additional documentation. I continue to stick to that information I've already provided.
Thank you. And are the answers that you provided in the ethics questionnaire and declarations that you submitted on the 2nd of May and the 16th of May in 2024, are they still accurate as of today?
Yes.
Commission members will now ask some additional questions. We will try to keep our questions short and to the point. We ask that your answers be short and to the point as well. Commission member Willem Brouwer will begin the questions.
Good afternoon, Madam Panov. You have seen the decision of the SCM. We have 3 items to talk about: the Keramin and the Kravita cases. In fact, those are 2 items. And then the judicial decisions that were examined by the European Court for Human Rights. And finally, we have to discuss on the asset and interest declarations you provided to the National Integrity Authority. We also received from you the Reevaluation, well, you know it. Thank you for that. We have taken notice of it, we have all read it, and you already mentioned a lot of items on this subject in this piece of work. Nevertheless, I want to start with the Keramin case. You know the problem that has been signaled over there. There was a pronounced decision and there was a written decision, and there was a difference between the both. Then the Supreme Court of Justice annulled the decision. In your explanation, and I keep it very short, you said this was an error. You admit it was an error. But the pronounced decision is always the most important decision, and that is the one that goes. So there was no harm done. Do you stick to that declaration, to that statement?
Yes, because, if I may continue my idea, because the effects of that decision are related to the operative part that was announced publicly. For this reason, everything that comes in the reasoning of a decision and the material errors that were made when providing the reasoning of a decision, it was only for that reason the Supreme Court of Justice annulled the case and sent it to retrial. That lady took advantage of that situation and they obtained a retrial of the case. We didn't cause her any harm.
You mentioned that this was more or less a clerical mistake, an administrative mistake. Is that correct? Have I understood you correct?
When reasoning the decision, I think only because of a huge amount of work, a mistake was made. And because it was Karamin Serele, meaning limited, and Karamin SA, meaning joint stock company. That's why a confusion was generated. But actually, I support the operative part that was announced publicly, and the reasoning of the decision was relying on providing documents to the unconstitutional authorities from Tiraspol, which we did not take into account. And for that reason, we rejected that lady's position that she provided, and that's why we said that Keramin won that case. I provided you now from that case file. The unconstitutional authorities make reference to the so-called customs of Transnistria, which we don't recognize it constitutionally. The banks that exist on territory of Transnistria, and they are not subordinated to the constitutional bodies of Moldova. They created their own authorities. The lady withdrew the money from Keramin account and put them in Transnistria.
Yes, because I want to go back to this decision that was taken, that was written. The oral decision that was pronounced is clear. But in the written decision, the claims of Keramin SA were omitted, and the reasoning stated that the Keramin SA's claims overlapped with those of Keraman SRL, and therefore were excluded. So, how do you explain that this is just a mistake, just an error, because there is a reasoning on
it? Actually, it's not reasoning related to the object of the lawsuit. It was related to the documents issued by those bodies. What I'm interested in, well, if I were to issue a different decision, I would have rejected the claims. You are judge. You know it very well. If I were to think that they were overlapping, I would have issued a decision rejecting the lawsuit.
Thank you. Colleague, do you have a question? Mr. Chairman, do we have a question on this matter?
No.
I would like to continue. Actually, there is a decision of the Supreme Council of Magistracy which is being examined in the Supreme Court of Justice, and all the objections you are mentioning will be examined by the Supreme Court because the decision of the SCM was appealed.
Or in your writing of today. Yes, thank you. I want to go on to this Karavita case. Well, you are familiar with the case. We have spoken about it in the first hearings, and you have spoken about it in your letter. If I understand you correctly, then you say that modification of the panel's composition was necessary. One of the judges fell ill, and then you replaced the chairman with another judge, and then the original chairman said, I don't want to do the case, and then you placed yourself in the panel as a presiding judge. That's correct?
I provided a very detailed explanation of the initial reason. Firstly, it was the sickness of the lady that was a member of a panel that was examining that case. And later on, when colleagues came At that time, I was acting president of a Court of Appeal, Court of Appeal Chișinău at that time, and now Court of Appeal Center. That is what was told to me, the discussions. I explained that in details. The judge's refusal to examine the case, not only Caravita case, but to examine all cases that they had pending. It was both the judge who refused to do it and the members of the panels who had other cases pending. The reason, I explained it in detail in writing. If you want, I can talk about it. But they started to accuse each other, and I intervened because it was necessary to exclude any potential doubt related to their bias. And that led to other problems for me as well. So, I decided so. In order to exclude this and not to bring up into public discussions everything that was happening within the court, meaning this lack of understanding among colleagues, I explained you how because I issued a decision changing the membership of the panels. I was forced to intervene in that situation.
Yes. So, we also write that you appointed another judge as president of that panel at first, because the original president of the panel would have less communication skills than the new one. How can you explain that?
The lady that was appointed president, she was a president of another panel too, and given her, and this was well known, her ability to examine cases, the way of leading hearings, because the lady is speaker of Romanian, the gentleman was a speaker of Russian, and that's why we wanted to have hearings faster and to have a hearing led by her, knowing her skills. I couldn't ignore that. That's why I decided to have that lady as the chair of the panel. And it wasn't only on the 1st of July. The lady got sick starting mid of June, and it lasted until September. So for that entire period of time, when it was needed to change the panel, the structure of the panel, it happened repeatedly, but the gentleman had a question about it only for the day of the 1st of July.
And this gentleman was kind of offended, but what I don't understand is you give his motivation that he was a Russian speaker and the lady was a Romanian speaker. Is this an issue that I can imagine that in Moldova there are more Russian speakers and also more Russian speaking judges. Is that a reason not to make someone the president?
I said it. It was not only her better command of a language, she had better skills to lead the hearings, she was faster, she knew the legislation better, and for that reason I decided it was appropriate to appoint her. But the gentleman's motivation was rather formalistic, that he's not going to attend that hearing because she's appointed the chair. Because he attended other hearings, he was part of the panels before, but at those times he didn't have anything against it. But when it came to Caravita and other related cases, he came to me and told me that reason, and that they started to have a lack of understanding, and they, well, called each other names, let's say, they were offending each other. I don't want to quote on that, because it's not nice for our judiciary. But things happened and I had to step in. It wasn't only because of speaking Romanian not so as good as the lady.
Is it normal that, the judge can refuse to adjudicate a case?
That was the question that I was asking myself, and I discussed a lot with that gentleman. This wasn't a decision taken in an instant. I'm sorry, but these discussions took a longer time for trying to make him go into hearings and examine cases. I don't know why that gentleman paid more attention to the fact that he had a quarrel with that lady. He put it above the interest of the justice. But this is a real case. This is how it happened, and the only thing I can say is what actually happened at that time.
And this gentleman was appointed as the chairman of this panel by the former president of the court, wasn't it?
Да.
Yes, and the lady as well,
Yes.
previously.
The lady that fell ill, I mean, that's a clear case. But did you really have the authority to overrule the decision of the former president to appoint this gentleman as a president of the panel in favor of this other lady?
Well, since there were discussions and lack of understanding between them, I was forced to intervene. It wasn't about me having or not having the right to do so, but to ensure more effective work of a court, because the number of cases is huge and they had to be examined, adjudicated faster. That's very important. When we have like 30 cases for every reporting judge, and there are 3 judges, that is up to 100 cases per panel. It's important to have an ability to examine cases faster. This can be checked looking at the statistics and who and how was examining cases. Because there is official statistics, no one is hiding that. This can be checked easily. So this is the reason why it happened.
Okay, well, to explain this. But another thing is, then you took yourself the place as a president in that panel. Was this? What do you think about it? Is it usual that then the acting president, because you were acting president, then is it usual that the acting president just places herself in this panel?
According to the regulation, well, the regulation states that the chair of the panel is the chair or is the president of a court, and as the case may be, the court president can appoint other judges as chairs of a panel. So in every panel that I become a member, if I'm the president of a court, it's mandatory for me to be the chair of a panel.
Yes, I know this regulation, but what I'm trying to ask is, how come did you place yourself in that panel and not another judge?
Because at that moment, that was the vacation time, and there were no judges that were able to go to hearings. And moreover, the accusations that were made raised suspicions, and I was forced to come. I explained that in detail in my statement regarding the hearing that I provided to you.
Still, one other question concerning Judge Pahopol. To modify a panel, there are very strict rules in your rulings to modify a panel. Which rule gave you the authority to change this?
Do you mean the first time or the 1st of July? Because 2 changes happened. First, the lady who was sick, and the second, that the gentleman refused to adjudicate cases and the accusations that were made.
Sorry, I didn't. myself clear. The first lady that fell sick, that's clear in the rules. If somebody is sick for a longer time, and I think she was sick for 4 months or something, so that's a longer time, no problem. But a judge who simply refuses to adjudicate a case, you decided to remove him from the panel. And what rule did you apply there?
The same rule or the regulation, judges' refusal to go into hearings. And it was an exceptional situation, and it forced me to decide. I either had to make public what was happening in our system, or I had to change the panel and continue to examine, because there were several cases that were examined on the day, heard on the day, not only Caravita, and the load of the court was big. Now it's big as well. It's much bigger than it was before.
Then now that you were only 15 days acting as president, I have read. This was a situation that one of the judges fell ill. You replaced that judge, and then you replaced that judge as a president of the panel, and that gentleman, Ms. Rahapol, refused to work in the same panel as the other judge. And then you said, well, then you go out and I come in. And since you, by default, you become the president of the panel, because that's in the regulation, that's how it went. It was an emergency, or it was a situation of great need, a lot of things to do, it was vacation time, and you wanted to go on with the cases. That is the motivation in a nutshell.
Sarcina care era curții la acel moment, dar
It was about the workload of a court at that time, but also the explanations that were provided by that gentleman. He categorically refused. And I didn't only decide to make this change, but I informed the SCM and I waited for the council to intervene.
Yeah. Thank you. Yeah, questions?
Domnul Panov, puteți menționați mai detaliat?
Could you please provide more details about the response of the Supreme Council of Magistracy about this case? Their reaction or response, you know that there is a conclusion where they redirected the materials without examining them. I don't know why they proceeded like that. I think this is not okay, but that's what happened. I am sorry because I expected an intervention of the Supreme Council of Magistracy when those things that were not normal, they were happening in the system and they were not normal, and the authority to decide on how to proceed belonged to the Supreme Council of Magistracy. I needed the support of the Supreme Council of Magistracy at that time, not only in that case, in several cases, because there were more of them. And I don't know why they turned a blind eye to that. They only sent them back without examining. Did you ask for explanation from the parties? No, not from me, not from the parties, not from anyone. I sent a lot of documents. I provided explanations of all participants regarding what happened. And the documents were drafted that Judge Bahopol postponed cases not in line with the procedure set by the law, because postponement conclusions or determinations were supposed to be issued in such case, but nothing like that was done. It was only mentioned in the case management system that it was postponed, and no procedural documents were issued.
Mr. Chairman, do you have questions on this subject?
I do not.
Okay. We go on with the ECHR cases. very briefly, you reacted on the Dietmansson Mindru case, and what I understood is that when adjudicating this case, you were assessing the circumstances according with national law and with European law or European case law. Do you stick to that statement?
Yes, and I would like to add that as far as the Mindru case is concerned, there is a very good motivation of the decision under the Law 87. The Law 87 regarding damages to be collected due to the extended or prolonged examination of the case. And I have been very thorough and detailed as to the period as well, as to why attention was not paid to the violations that have occurred because of the conduct of the party. Now, we couldn't have explained that, but in our decision there is an explanation laid down, and what has happened is that the case was pending from 2014 to 2016. Otherwise, the person went to court and the evacuation of the brothers from the house, but then it turned out they were not even informed, and they had to go for a retrial, and several requirements were put together. And then the woman was no longer the plaintiff, but she was on the other side, the defendant now, because of that inheritance certificate that came up. So everything related to the property then was annulled, declared null and void, and then regarding the land plot as well. So in 2016, there's an appeal that is filed, and the issues from 2016 to 2018, in that period of time, the issues haven't been solved, so the case was not examined on the merits. What happened is that actually it's her behavior. That's why the case was not examined in a quicker fashion. It was not on the court. The court has provided time for the issues to be addressed and for the appeal to be examined, but they did not pursue this flow of steps. And then, the court again allowed time, but the issues have not been solved. And ultimately, it ended with the appeal not having been examined, so that is from 2016 to 2018. And then that lady regarded herself as an applicant, went to the European Court and asked for damages to be paid. But we've explained in our decision all the ins and outs, because the way of issuing that legal document was practically the same as for the European Court, and it all was related to the complexity of the case.
Thank you. Still, I have some questions on that. The European Court decided or saw that this total procedure lasted more than 7 years, and only 7 months were due to the applicant. That's one thing. And in that respect, I would like to ask you, what do you think are the conditions of Article 2 of the Para 3 and 2 and 3 of laws 87 to 11 concerning the conditions for granting compensations for this excessive length of a procedure? Because in your explanation you said there was no fault by the court, but this is an objective item. So please explain me how you interpret that excessive length.
In this particular case, I would say that this term, the European Court was calculated 7 years and 7 months, and 7 months only due to conduct of the applicant who became a defendant, but it was not taken into account. So as a court, we took into account her conduct as well. She has initiated the evacuation of the brothers, but she did not inform them for them to be aware of the the case that the court was looking at. So the court has sent out the summons to the addresses that the woman, that lady indicated. But ultimately, she did not try to reach common ground with her brothers, or did not put them in the know. She did not tell him, look, this is happening, this is going to happen in the court, so that you know. But actually, they were informed much later. And from 2014, when the case went back for retrial, it's only then when we can put it on the court, the examination duration, that is, because once the retrial or re-examination has happened, a lot of procedures were triggered, judicial expert reviews, looking into signatures in the Inheritance Act, for instance, and these are lengthy procedural activities, so they take time. So we can't pin it on the court again, this one too. And because we've just reached a situation, a point in time where the lady has tried to find ways to delay things and to divert attention, and we've also argued our decision, the accumulation of cases that we joined, and then there was the local public administration involved as well. A number of actions have been taken, and we can't say that they are about the court alone. It's about the parties and the way they've acted.
At the time of your decision, were you aware of the jurisprudence of the case law of the European Court on this reasonable length of proceedings?
I can't say I was not aware of that. I obviously was, but we are also factoring in the concrete specific circumstances of a case you are dealing with. You can't say that there is a particular deadline or term, duration for every case, one for all the cases. There's the peculiarities of every case that have to be taken into account as well, the specifics of a case, and you are looking at it all together when you are thinking of how long it has to take for a case to be examined. And in that particular case, what was a factor was also the conduct of the participants, of the parties concerned, how they were getting involved with the examination.
Because it was stated by the European Court that only 7 months of these 7 years were due to the behavior and the conduct of the party. And then that makes that the reasonable time limit has been passed, and something should be done. It's imperative. So that's why I'm asking you, how did you interpret this Law 87/2011 on this matter?
When it comes to the calculation of the duration as set out by the European Court, certainly they are mandatory for us. That is, there's no question about it. It's just we have regarded the calculation of the duration in a different way, because I think that perhaps the court did not have all the documentation. But 2016 to 2018, when the appeal of that lady, when she was already in the capacity of defendant, well, that one had not been examined for 2 years long, only because of her. Because the issues have not been settled. The appeal would have otherwise been reviewed, examined much quicker if she contributed to its faster examination, if the issues had been dealt with, and then everything, the appeal that is, would have been examined as set out by the law and on the merits.
And the Tasson.com case, revision was asked due to, an annulment of the criminal case or an acquittance in the criminal case, and there was the tax case of VAT, and as far as I understood there was a VAT assessment with fines, administrative fines. Is that correct?
Right now, I am looking at that decision, and I don't find a word here in this decision regarding the criminal case. But the object of the examination in the administrative court that happened in 2012, that was looked into the legality of this decision. But it's just that additionally, the tax inspectorate, back then, when it challenged the decision by appeal, so there was a Orhei court decision that said that Tascom was the winning party. But then there was a conviction at that time, and we've already looked at it as from the point of view of the appealing party. It was not as something that was established in the decision. That was an act that was issued on the basis of the tax law. That was about the violation of the VAT rules, and that implies some penalties. And back in those years, 2007 to 2012, 2013, around that time, there were frequent cases of tax fraud, and specifically that they were applying for VAT deductions when they would not pay to the government, but they would go to the state tax service to have reimbursement of VAT without having paid anything into the budget of the country. And it is unfortunate that the prosecutor, when the acquittal was issued, Macovei Alexandru, he took no measures to appeal against it, to challenge it. When in 2015 a revision was applied for, referrals were made only to the acquittal sentence that was issued on the 27th of December 2013, but entered into force on the 12th, if I'm not mistaken, or the 13th of January 2014. And it's unfortunate that no measure was taken. And from then on, I have purposefully asked the State Tax Service for information regarding the debt of this company, Tascom. Currently, 40 million is the amount of the debt. Nobody has managed to get them to pay it, to pay the debt, Tascom that is. So those who are listening to this, to what I am saying, I hope that the other businesses will be upset about it as other business owners. How comes that sometimes just at the end of the month everybody is paying their VAT and others are just let off the hook? The VAT does not belong to the seller or the buyer company, it's of the government. And the government has to collect that immediately. At the end of the month, a report is to be filed and what is due is to be collected.
That leaves me with a question. There is a request for revision. Sorry, I couldn't find the word. There was a request for revision, and requests for revisions are dealt with on the basis of Article 449 of the procedure law. And as far as I know that article, it doesn't say that you can't revise a case when tax has not been paid. I think Article 449 clearly states what the criteria are. So I don't understand why you didn't revise it. I still don't do. So please explain me that.
Now, the object of the examination in administrative court, that's what it used to be like that. So there was a decision of the State Tax Service as a basis. It was not a sentence convicting or acquitting anyone. And for that reason, as tax violations had been established, we did not take into account the acquittal sentence. And it is the discretionary right, not the obligation of the court to mandatorily revisit that decision. I found no grounds. It's not an imperative obligation to revisit or to review that decision because those obligations have not been properly lived up to and the VAT had not been paid. And that would be one of the reasons. But the Supreme Court of Justice upheld our decision. They believed there were no grounds for that revision.
Okay, that's your explanation. Do you have any questions on this? Mr. Chairman, do you have any questions on this? No, thank you.
I do not.
Well, then we come to the last subject. That's the declarations of your wealth, your assets, and what I read in your letter of today. You have named them all, you have described them all, and you say in every case, whatever it is not enough to dismiss a judge from office by these separate mistakes in declaration. Do you stick to that? Did I understand you correctly? Let me ask it first. Did I understand you correctly?
Poate eu n-am înțeles ce...
I might have misunderstood what you meant. What specifically are you asking me about? Are you asking me about the Caravita case again?
No. I'm asking you about your the declarations you did for NIA.
Mhm.
Yes? There are some mistakes made in those declarations. It's about loans, it's about assets from selling of property, of movable property, etc. You described in your letter these cases, and your conclusion is, with every case, you say, but this is a small error, I didn't become richer or poorer, so this is not enough to dismiss me from office. Did I understand your writings correctly?
Dar nu consider că eu am încălcat.
Well, I don't think that I have violations. Indeed, those mistakes that I have made with regards to the amounts declared by my husband, I did not check that. I did not check what income he has obtained for me to put it down identically in what I reported to the NIA. But the Commission carried out an assessment on the basis of the actual income earned by my husband, not on the basis of what I reported. What I reported is what corresponded to the total income of the company, of the business of my husband. And when expenses were subtracted, we've achieved that amount of net, so to speak, income. And that's why the assessment you've carried out for the first round, for the first evaluation, let me call it that, I don't mean the resumed evaluation, but the initial evaluation. So at that time, your work was based on those amounts that were the actual ones, not the ones that were mistakenly reported. And I agree with the way the Commission did its assessment.
I've also seen that SCM has stated that there might be some, let's say, misdemeanors, but they should be assessed by the Commission, by our Commission, as a whole. Do you have any comments on that?
I would like to understand, what do you mean as a whole? Address them as a whole, as in what? As a whole, with all of the situations regarding the ethics, you mean?
Yes.
I believe I haven't violated judicial ethics, and those minor violations that have been committed, they're not as bad as, they cannot lead to me being dismissed from office. They're non-essential violations that have taken place when I was given huge responsibilities.
Just a question that doesn't make a difference at all, but you just said I was not aware of what my husband should have declared, and I was only declaring what I knew. How do you do that nowadays?
Now I mandatorily check. Now I look into the accounting documentation. I ask to be provided with the accounting documentation that is also filed with the state tax authorities. So what is reported to the tax authorities, that's why I report as well. But it's also, that in sole proprietorship is just like a natural person. So the questions are worded in a way that I don't know how to precisely report. To report the assets or the wealth of the sole proprietorship, or what my husband has as a natural person. Even the way the questions are worded in the reporting form, it's not clear enough. And I have reported even assets registered with a sole proprietorship. I've declared even that in the declaration, so as not to allow for any questions as to why I did not report. And the two cars, well, they're registered on the sole proprietorship, not on the natural person. They're not registered like that. So I've reported that. And not only the car, but also the trailer and the Toyota. It's only to avoid any questions about my fairness. I decided to have an exhaustive reporting, so to speak, regarding all the assets of the natural person and of the sole proprietorship, because I wouldn't want any questions to appear about what it was reported for the sole proprietorship and the natural person when it's actually one and the same, practically.
Thank you. Colleague, questions? Mr. Chairman, do you have questions on this subject, to this subject?
No, I do not.
Well, then I have finalized my part.
Commission Member Gațcan, do you have any questions you'd like to ask?
No.
Okay. Judge Panov, that brings us to the conclusion. Is there anything you'd like to say before we end the hearing?
I hope you understood me right. I believe that I did not commit violations. Mistakes may be possible given the amount of work and the tasks that are set for me, and I am human, and humans make mistakes.
For your submissions to the commission and the information that you've provided today. That then will conclude the hearing. After the hearing, the panel will approve an evaluation report stating its conclusion whether the subject meets the criteria for ethical and financial integrity under law number 252. The commission will strive to complete and approve its evaluation report and announce its conclusion as soon as possible. The hearing is now closed. Good day to everyone.
Good day.